Today I will be presenting a case that involves a likely Eighth Amendment violation in a correctional setting. We'll walk through the history of the Eighth Amendment, explore real-life violations, apply that knowledge to the case study, and consider the legal consequences for both individuals and institutions. The Eighth Amendment was adopted in 1971 as part of the Bill of Rights. It comes from the English Bill of Rights of 1689 and was created to protect individuals from harsh and excessive punishment by the government. Specifically, it prohibits excessive bail, excessive fines, and cruel and unusual punishment. Over time, courts have interpreted this amendment to apply to conditions in jails and prisons, including how inmates are treated by staff. One example of an Eighth Amendment violation is excessive use of force by prison staff. In Hudson v. McMillan, a handcuffed inmate was beaten by 2 guards, even though he posed no threat. The Supreme Court ruled that any unnecessary force that's sadistic or meant to cause harm violates the Eighth Amendment. So it's not just about serious injury, it's about the intent behind the action. A second violation involves deliberate indifference to an inmate's serious medical needs. In Estelle v. Gamble, the court held that ignoring or delaying treatment for a prisoner's injury or illness amounts to cruel and unusual punishment. This case helped establish that prisoners have a constitutional right to adequate medical care and that ignoring these needs is a serious constitutional violation. A third kind of violation relates to unsafe prison conditions. In Farmer v. Brennan, a transgender woman placed in general population was raped after officers ignored known risks. The court ruled that if prison staff knowingly ignore serious threats to an inmate's safety, they are acting with deliberate indifference, which again violates the Eighth Amendment. In our case, a mentally ill inmate in a manic state assaulted a correctional officer. Instead of handling the situation according to protocol, another CO retaliated by placing the inmate in a cell with 2 violent offenders and encouraged those offenders to take care of him. This puts the inmate at serious risk, and it was intentional. That kind of deliberate exposure to harm, especially for someone with a mental illness, meets the legal standard for cruel and unusual punishment. It's a clear Eighth Amendment violation. If criminal charges are pursued, the correctional officer who arranged this retaliatory placement could face charges like official misconduct, conspiracy, or assault by proxy. These charges would depend on state laws and whether prosecutors believe there is enough evidence to prove intent. Still, the possibility of criminal liability is real in cases like this. On the civil side, the inmate's family could file a lawsuit under Section 1983, which allows people to sue government officials for violating their constitutional rights. The facility could be held responsible, especially if there's a pattern of misconduct or inadequate training. The court could award compensatory damages for medical treatment and suffering, and even punitive damages to punish the wrongdoing. This kind of incident could bring major consequences to the jail as an institution. There may be a federal investigation by the Department of Justice's Civil Rights Division. The jail could be required to change policies, increase training, or undergo regular oversight. It could also lose funding or face expensive lawsuits. Incidents like these damages both the jail's reputation and its ability to function safely. From an ethical standpoint, correctional officers are responsible for maintaining safety, not just for staff, but for inmates as well. Retaliation, especially against someone in a manic state, crosses the line. In such stressful environments, professionalism is key. Letting emotions dictate decisions is dangerous and unethical. Every inmate, no matter what they've done, is entitled to humane treatment. The appropriate response in this situation would have been to isolate the mentally ill inmate for safety, not retaliation, and refer him for a psychological evaluation or treatment. The retaliating CO should be disciplined or removed, and the facility should review its mental health protocols. Staff training around the Eighth Amendment and mental illness could help prevent this from happening again. In conclusion, the Eighth Amendment protects against more than just physical punishment. It also ensures inmates are not exposed to unnecessary harm. Our case study shows how a CO's poor decisions, fueled by retaliation, violated that right. The legal, ethical, and institutional consequences of such actions are serious, and this case is a reminder of how critical accountability and proper training are in correctional settings. Thank you.